Very good morning, ladies and gentlemen, and warm welcome to you on this webinar on a subject which has evoked great deal of interest, which is the new rules and the regulations on the overseas direct investment. And it is not surprising to see why there is such a lot of interest on the new regulations. First of all, we are seeing an increased level of activity in global investments from India, be it, for example, the multi-billion-dollar acquisition by Viacom of the Viatrix business, several other transactions happening really on the global side. Adani is acquiring the SoftBank portfolio, etc., etc. So we are seeing a good amount of activity. And as we see this good amount of activity, we also see two other things which are a very important phenomenon. Most large Indian businesses would like to diversify their portfolio. Most large families are intending to diversify their portfolio, want to have a base outside of India. And the moment you start doing that, you encounter a number of questions under the existing ODI regulations. There are issues regarding whether the investment that you make are in financial services, not in the financial services sector, what constitutes financial services, how does one interpret that term, what is strategic investment, what is not a strategic investment. So you had a number of open issues, and the fact that Indian corporates wanted to diversify, wanted to go global, Indian Family Office wanted to diversify and go global. And then we have had always this ubiquitous question as to what constitutes round tripping. Is an acquisition overseas with a marginal investment in India round tripping, not round tripping? Does it require monies to go out and come in back? Is only then what constitutes legitimate business activity to fall foul of round tripping, etc. So a number of issues which were open out there. And it was almost a year to the day back, maybe slightly more than a year, that on 8th August 21, the Reserve Bank came out with draft new regulations. And for a change, rather than simply notify these regulations, there was a consultation paper, representations were made. We accompanied a number of potential investors going to Reserve Bank, talking to them about thought processes. And after almost a year of deliberations and bureaucratic back and forth, we now have the new regulations in place. And ever since the new regulations have come out, our telephone calls have not stopped. People calling us, wanting to ask questions on interpretation, etc. People who are very, very delighted at the new regulations, and people who are not so delighted, people feeling it's very, very positive, others feeling it's even more restrictive. And over the last day and a half that the regulations have been around, we have had sort of discussions internally with clients, etc. And today we present to you our analysis of the changes that have taken place. And as we present you this analysis, I must tell you that the number of situations that one can deal with is not what one can fathom in a day and a half. New situations will keep on evolving, and one will read, reread, and reread the regulations to see what is within the regulations and what is foul of the regulations. And as we present to you, we are deeply conscious of two other things. One is that ADs, authorized dealers, banks are going to really, and they are responsible for the implementation, and they are going to come back with their own thought processes. I'm pretty sure Reserve Bank might want to clarify a few of the things. And as we present to you our thoughts, we are acutely conscious that regulations such as these need to be interpreted in their spirit and not merely the letter of the law. And again, as I said, this is an evolving situation, so I don't think we have all the answers. But what we have tried to do, and what we will do over the next about 45 minutes, is to present to you certain salient aspects of these regulations. And then I'm sure that as we deal with specific situations, we'll be happy to answer those questions. I have two of my colleagues on the call. Abhishek is going to be talking about regulations insofar as they impact other than the financial services sector. And then Punit is going to talk about the financial services sector and everything else that deals with it. I'm sure you will find the discussions engaging. I'm sure You will find these discussions very, very relevant. There is a chat box, so feel free to drop in your questions. And to the extent that we can address them, we have reserved some time for Q&A, and we'll try and answer them on this webinar itself. So insofar as we are unable to address them due to paucity of time, we'll be happy to write to you and sort of clarify your things. So with that background, if I can now invite Abhishek to go in and start his presentation. Abhishek, the floor is yours.
Thanks, Dinesh, and warm welcome to everyone for joining this webinar to discuss on this important topic. Dinesh has already given the brief, so we can directly delve into the key aspects of the new legislation. So just giving the background and the context in terms of how from a regulatory perspective, the regulations have evolved. So as we have already known, all the overseas investments were governed by the FEMA 120, as we popularly known as from a foreign ODI guidelines perspective, which covered the investments into the overseas securities as such, and there were regulations governing the investment into direct immovable property. Again, to liberalize the regulatory framework and also in terms of ease of doing business amongst other things to be achieved, RBI issued the draft rules and regulations which governed and which in a sense overhauled the overseas investments regime, which was came to the public domain on 9th of August. And various representations and were made in terms of those draft regulations. And ultimately on 22nd of August, there were multiple legislations that were notified and released. So there were rules that were notified, there were regulations that were notified, and there were directions also were notified, which governs the overall new ambit, which will govern the overseas investments to be made from India to in an overseas jurisdiction, including through an IFSC also. These regulations are effective immediately as such. So as we are seeking, these new regulations are applicable. So anything pertaining to overseas investments would now be governed by these regulations, which is in complete supersession of the erstwhile ODI regulations and also in respect of the circulars which have been issued in the erstwhile regulations. It is very important to know that initially the rules and the regulations were notified, and in the very same evening the directions were given. The rules and the regulations are generally governed in the policy aspect of the overseas investments to be made, and the directions are given to have an effective implementations of these rules and regulations which are notified. So there are certain aspects which have been mentioned in the rules and regulations, but which have been further clarified in the directions, which could be maybe in contradictory or not in contradictory, in difference in what has been mentioned in the rules and regulations, and providing further more clarity on that. So from an ideal perspective, one have to read all the three regulations in harmonious to come to a particular conclusion, rather than just relying upon a particular rules or regulations and interpret a particular aspect therein as such. So as we discuss down the line, our view or analysis would be for in terms of encompassing all the three aspects, all the three legislation which has been enacted, to see what is the ultimate implementation that is arising out. The government has mentioned that these rules or the regulations, the new ODI regulations which are there, are covering various changes in order to be much more objective, reduce the subjectivity, and provide lots and lots of clarity as such. So the highlights which they have mentioned in their direction document is that it has brought in an enhanced clarity, and actually we will see once we are discussing the various points that there is more of an objective criteria or objective clarifications which have been provided for various definition concepts and all, as compared to a subjective aspect which were there in the erstwhile regulation as such. They have introduced the concept of strategic sector in terms of further liberalization or further rationalization, the ability to make investment overseas in an entity which is not incorporated or registered. So say, for example, a bidding or through consortium, it can now be in a sense possible if they are falling within the part of the strategic sector. And we will discuss as we go down the line, which are the sectors covered and how it liberalize or rationalize the decision making in this, the investment making in this sector as such. The critical aspects in terms of this new regulation, if I have to say, that they dispense with the requirement of approval for various transactions. either you call on the write-off of investment, or either you call for the deferment of the payment consideration, and many more aspects of this, as we will discuss, which are there, which is in a sense very, very welcoming as such. They have provided a window is also available as a part of a transition from the old regulation to the new regulation, that if there are any reporting delays under the old regulation, they can make good that by paying the late payment fees as prescribed under the law. And in a sense, we can come clear in terms of past delays or irregularities as such. So this was the brief background in terms of how it has transferred, the new legislation has transferred from the earlier regulations as such. The first and foremost question is that what happens to the investments which are already made under the earlier regulations, and how it would be seen or viewed in terms of its compliability from a new legislation perspective. So there is a transition provision which they have clarified to say that all the existing overseas investments which have been made in accordance with the erstwhile regulations which are there, they shall be deemed to have been made in compliance with the new regulations, and everyone can continue to hold or transfer the same, albeit in accordance with the new regulation as such. Conversely, it has also been therefore clarified that if the current investments, overseas investments, are not in accordance with the erstwhile regulations, then they cannot be held as well as transferred in any manner whatsoever, in a sense, therefore, unless those are regularized. And the importance of this we would see in some of the transactions which we will discuss subsequently, and how it impacted that if there are any overseas investments which have not been made in accordance with the regulations, and for which an application is made for regularization of the same and all, there has to be furthermore asked for dispensation to continue to hold this unless the approval is granted by the RBI, which would be very, very relevant. Second, those overseas investments which have, for which regularization application is not being made, for them also going forward, one have to seek an RBI approval for seeking regularization. Otherwise, they cannot hold the same or transfer it in any manner whatsoever. Even though currently those investments may not have been picked up by RBI as in violation or as in not in compliance with the erstwhile regulations as such. Now, this is the heart of the new legislation which has come. Just to give the context, under the erstwhile regulations, the erstwhile regulations governed only, or it categorized the investment, overseas investment, into two categories: the ODI route and the OPI route, overseas direct investment route and overseas portfolio investment route. The regulations only govern the ODI investments which were to be made from India to overseas, and the OPI route as such were not directly governed by the erstwhile ODI regulations, but we used to have those investments made through the LRS scheme that were applicable as such. And what was ODI and what was OPI, there was no clarity, and it was completely a subjective test which were there with a very, very, very limited guidance on this. So it was completely at the discretion to interpret that and also seek RBI approval wherever there was any doubt. But what they have done away with that, they have brought in a clear definition in terms of which overseas investment will constitute under the ODI route and the OPI route. And secondly, any investment to be made under the OPI route are also in that sense governed by the new legislation. So the new legislation is all encompassing any overseas investments into the foreign securities outside India, and no one have to look into any other legislation, i.e. the LRS scheme which were there earlier. So what are these two important definitions which are there? Under the ODI route, acquisition of any unlisted equity capital of a foreign entity would be treated as being part of the ODI route as such. And it has a ramifications on various aspects of the transactions which we will discuss, and therefore this is the most critical point from the perspective of the definition of the ODI route which is there. The second, if there is any subscription to the memorandum of association of a foreign entity, that also would be treated as a part of the ODI. In terms of investment into the listed foreign company, foreign entity, it would be treated as ODI if the investment is more than 10% of the equity capital, or investment even though less than 10%, but that investment entitles control then that also would be treated as ODI route investment. It is also clarified that once you satisfy the initial limit and constitute a particular investment as an ODI, any subsequent fall in the threshold limit, say a 10% equity state is going down, or subsequently there is no control, even then that investment which is continued to be held even after the fall in the threshold limit shall continue to constitute as an ODI investment route, and the consequences thereon in terms of reporting and everything will follow. The most important element here in terms of what do you mean by the control, and this again have ramifications upon various transactions into interpret whether a particular transaction have to be done in a which manner depending upon whether the control is there or not. So apart from the normal definition of a control, which constitute as 50% of the board directors or having control over the managing right, they have brought in one more objective test to means that control means which entitles 10% or more of the voting rights in any manner through equity participation, to management shareholders agreement or whatever, that would be treated as control. So the sum and substance of this is that by default now any investment into the unlisted equity capital of a foreign entity would be covered under the ODI route as such, and there are various clarifications which have been provided in the directions wherein they have mentioned that even though it is an investment into the unlisted equity capital, then too they would be treated as not an ODI investment but an OPI investment, which we will see later on. Now conversely, if we see the definition of an OPI, it means investment other than ODI. So I have to first test whether an overseas investment falls within the category of ODI route. If it falls, then the OPI option is not available to me. So any investment in an ODI, but it does not include, there is another negative condition, any investment in the unlisted debt securities or any security issued by a person resident in India who is not in IFS. So if an investment is not an ODI and also not a listed debt instrument, that what gets covered under the definition of the OPI as such. So, and further it has been clarified that therefore investment into equity capital of a listed entity which is regarded as an OPI, even after delisting, it will continue to be considered as an OPI unless any further investments are made. So largely investment into listed securities, largely which is below 10% or not having control, are forming part of the over OPI route as such. So there are two important takeaway from this slide which would be there. A, unlisted equity by default is treated as an ODI investment, and second, unlisted debt instrument is not a route available under the OPI route as such. Now, these are the definitions which are provided under the rules as such. But if we go to the directions, what do you mean by, so before going that, what do you mean by debt instrument? So debt instrument, they have defined it under the rules to include corporate bond or borrowings through any loan. And they also included what do you mean by the instrument which are not a debt instrument, which are more likely the equity or personally convertible or anything which is forming part of the non-debt regulations or what is commonly known as the FDI regulation as such. It is important that in this definition of debt instrument, they have not mentioned anything about the pref capital as to whether it will form part of the debt or it will form part of a non-debt instrument as such. But in the directions, they have clarified that any redeemable or optionally convertible instrument or an irredeemable or a redeemable instrument or an optionally convertible instrument will be treated as a debt. So here is a situation wherein the definition of an debt instrument do not mention anything about pref capital, but in the directions it has been clarified that those pref capital, it would be either in the form of a redeemable pref capital or an optionally convertible pref capital, which would be treated as a debt as such. So therefore, any OPI investment into unlisted debt, including preferred capital, may not be permissible under the OPI route as such. As I mentioned, while these are the definitions provided under the rules, but there have been various case-specific clarification provided for a particular investment, whether those will constitute as ODI or OPI in a sense, irrespective of what is stated in this definition as such. And hence, one would wonder as to what one have to rely upon while interpreting the term. As Dinesh also mentioned, that it have to be interpreted in spirit and not with the letter of law as such. So one have to give a harmonious interpretation, or one have to do all the three documents issued to see in which category it will fall, whether under the ODI or the OPI route. So as we discussed, there would be certain other elements of, we will now discuss now which are the forms of the various options available for the overseas investments and what are the governing regulations pertaining to the same. I now hand it over to Puneet to take forward here on the investment from a financial services sector activity perspective.
Thanks, Abhishek. So in next few slides, what we have tried to cover is the investment in the financial services sector overseas. And there are substantial liberalization, there are substantial changes. Some are like liberalization, some are like restrictive changes, and we will just look at those amendments. So first, if you look at ODI in the financial services activity by an entity which is engaged in the financial services in India. Here, there are not many changes which have been proposed. Earlier, what was permitted is the entity in India has to be a financial services entity. That is number one. Number two, it has to be registered or regulated by a financial services regulator in India. Those conditions continue. It has to have a 3-year profit track record. That continues. And the Indian entity has obtained required approval from the Indian regulator, which could be RBI, which could be SEBI, which could be IRDI, to make those or carry on the financial services activity overseas and got those approvals. The significant change here is as underlined in the third bullet. It says the financial services approval as may be required or as the case may be. Now, those words were missing in the current regulations or the old regulations. So I think it's very significant change, because what we have seen in past, that in several cases, Indian entities were constrained in making certain investments in financial services outside India because those activities were not regulated by the host country regulator. And now this particular regulation provides that if the registration or the regulation is not required by those regulators, then even after such a situation, the investment, ODI investment would be permitted. So I think that's a very welcome suggestion. There is a very welcome modification. And I think that would open the ODI route for several financial services activities, which are as such not regulated outside India. Of course, ODI by banks and non-banking financial institutions, which are regulated by RBI, they will continue to be regulated by those respective regulations as well, not necessarily the ODI regulations, but the respective RBI regulations governing banks and non-NBFCs, where again there are several restrictions, including the regulations of the activities in the host country. So those activities would continue to be regulated, and those approvals will be required under those regulations. So again, as you can see, not a very substantive change, but a key change in terms of whether the financial services activity overseas is required to be regulated or it need not be regulated, and still the investment is possible. So that's a welcome change. One important change which has been made so far as AIFs are concerned, the AIFs in India now can make investments as OPI into overseas companies without having India connection. So I think that's again a very significant liberalization. Earlier, AIFs were constrained in making investments overseas into several startups because those startups or those companies did not have India connection or India activities. Now that restriction has been done away with. I think it's a very, very significant and very welcome change again. So AIFs can now make investment in the overseas companies without any restriction of having India connection in India. So I think that's something which is a very significant change and quite welcome. Yeah, Abhishek. Now, this is very, very interesting. The new concept or the new provision has been introduced. ODI by the Indian entity which is not engaged in the financial services activity, and the ability of such entities to make investment in the financial services activity outside India. Very interestingly, now this is permitted without any restrictions. The only restriction which is now provided is that the Indian entity has to have the track record of profitability for 3 years, which is of course there in the for the financial services entity in India as well. And the same restriction applies for the non-financial services entity in India, but no other restrictions apply to such an entity. So in a way, the non-financial services entity in India making investment into financial service activity outside India is much more liberalized, does not require any approval for making those investments into a financial services activity outside India. A very, very significant change and a welcome step again. The interesting proposition or interesting situation will arise as to whether investing activity being carried on outside India, can it be termed as financial services activity? Number one. And number two, whether any Indian entity which is into non-financial services business, say a manufacturing entity, can make such an investment. So can it create an investment vehicle outside India for making investment activity, which is like a financial services activity, and continue to make those investments outside India, which are as such may not be permitted under other provisions of the ODI regulations. So a very interesting situation arises because here no approval is required. It is under automatic route. Of course, the 400% of the net worth condition would apply because that's a overall restriction in the ODI regulations. But other than that, can an Indian entity which is not a financial services entity make an investment into investing activity outside India and thereby make investments into several unlisted and listed portfolio companies outside India? It's an open question. On the face of it, it would look like that such a activity should be permissible because today those restrictions would apply considering that as a financial service activity, and those restrictions are proposed to be liberalized under the new regulation. So there seems to be a window for making this investment activity overseas, but one would need to further look at the fine print, talk to the authorized dealers and if required RBI, and come to the right conclusions. Yeah, Abhishek. A very interesting and significant change has been made for investment in the units of investment fund overseas. There are some issues there, but I would just first deal with the conditions which are being prescribed under the rules or under the directions, RBI directions. The direction says that going forward, investment in units of investment fund would be permitted and it will be considered as OPI, overseas portfolio investment. Now the question is, as per OPI regulations, and Abhishek dealt with it partly and he will continue, he will deal with it in subsequent slides as well, that as OPI regulations, listed Indian entity up to 50% of the net worth and the resident individuals up to $250,000 under LRS scheme are eligible to make such investments. And even today, if you look at the regulations, those are the limits which are prescribed under the ODI regulations. So what has changed because of this is that unlisted entities in India can now make such OPI investments. Now that takes me to the third point, where whether these investments are ODI or OPI. Now that question arises because, as we saw in the previous slide, any investment into an unlisted entity is considered to be ODI and not OPI. While the directions specify this as OPI, it's slightly inconsistent with the ODI rules and regulations which term investment into unlisted entity, unlisted foreign entity as ODI. However, direction says OPI, and therefore it is permitted for the listed companies as well as for resident individuals. That is number one. Number two, the direction says that this is investment in units of investment fund overseas. Now, as we are aware, in most cases, the overseas structures of the investment funds are corporate, unlike India, which are in trust form. And the corporates would actually issue the shares. Either it could be equity share, either it could be class B share, it could be a preference share, it could be a redeemable instrument, it could be any instrument which as the fund constitution may permit. And the issue arises again is whether this would constitute an ODI or it would constitute an OPI, because again it would be slightly inconsistent with the definition of OPI, which permits investment only in listed instrument. And most of these fund entities would be unlisted entities. And therefore, can it actually fall as ODI and not OPI? And the implication clearly is that ODI has much larger limits, which is 400% of the net worth of the entity which is making investment, while OPI has the limit of 50% of the net worth for both listed and unlisted entities, as well as USD 250,000 for individuals. And the third confusion which could arise is the definition of debt instrument. Again, Abhishek dealt with it as to what constitutes debt instrument. If the fund, overseas fund, issues redeemable preference shares, whether it would constitute a debt instrument or it still falls under OPI, or would it fall under ODI? Unfortunately, there is no clarity when you read the rules, when you read regulations, and when you look at the directions, there is inconsistency between both the provisions, and therefore one would need to analyze the situation and then take an appropriate decision. But having said that, clearly there is a liberalization in terms of enabling provision for making investment in the units of investment fund overseas. Of course, we'll come to the next slide in terms of investment in the gift city when this vehicle is situated in gift city. But other than that, the OPI investments are now permitted, especially for unlisted entity which can make an investment if it is in under the liberalized provision of gift city provision. So subject to this inconsistency of ODI versus OPI, it's a very significant liberalization. Yeah, Abhishek. And coming to investment in IFSC, a very significant boost to the entities to set up their structure in gift city, because as we saw, several restrictions which are there currently, they are actually removed for the investments which are being proposed in the entities which are set up in gift city. So the first one is that investment in the in IFSC by the person resident in India will be treated as overseas investment, and ODI rules would be applicable. Now, first is the Indian entity which is not engaged in financial services, as we saw, can make investment in financial services activity, but it required a net profit track record for 3 years. Now that restriction goes away if the Indian entity wants to make investment in a financial services activity in IFSC. A very, very significant relaxation. Number two, resident person, Indian entity or an individual is allowed, as we saw, to make investment in IFSC as OPI. And now this overcomes the restriction of unlisted entity for making OPI, because those restrictions are done away with for a unit which is in IFSC. And similarly, however, whether 50% of the net worth restriction continues or not, that one would need to see. But it appears that any investment by the Indian entity or individual in a gift city financial services activity would not be restricted by the restrictions which are provided in the normal ODI regulations. And the third one, resident individual is allowed to make ODI in the financial services activity in IFSC again. Now that is again prohibited if the financial service activity is being carried on overseas and not in GIFT city. An individual could not have made an ODI investment into such an entity, but it's now permitted if the activity is being carried on in GIFT city. Of course, there is one condition in terms of step down subsidiary not being controlled by the individual, but subject to that, almost all restrictions which would apply for an Indian entity which is listed or unlisted, or an individual for making ODI investments overseas are done away with if the investment is proposed to be made in GIFT city. A very significant relaxation and significant boost to the setting up of the structures in GIFT city. Of course, and another change is requisite approval by the financial services regulator shall be decided within 45 days. Otherwise, it would be considered to be deemed approval. So significant relaxation to the process as well for the approval of setting up the structures in GIFT city. So overall, I think there seems to be very material relaxations for investment into financial services activity, either overseas or in GIFT city. Several restrictions in terms of the net profit criteria or certain other restrictions have been done away with. And one would need to see as to in terms of the interpretation issues between ODI and OPI instruments, etc., what kind of views are taken by the Reserve Bank or the authorized dealers while granting or allowing these remittances. Yeah, Abhishek. So, yeah. So I think Abhishek, you can take it forward. Thank you. Abhishek, you are on mute.
Okay, sorry. Just continuing in terms of what are the other key changes pertaining to any ODI investment to be made by an Indian entity outside India, which are there. So the first and important point is from a perspective of carrying on the bona fide business activity. So this was the condition even under the earlier regulations that a foreign entity to be engaged into a bona fide business activity, which they are further clarified to say that it has to be activity carried out directly or through the SPV, which is there. So even under the earlier regulation, one had the ability to carry out the or make the investment into an operating foreign entity through an SPV structure, which continues to be, but there is an added point to here that they have not defined the term. What do you mean by a bona fide business activity? Earlier, as I mentioned, it was always a subjective criteria, and it more so have relevance from the round tripping structure, which we'll discuss. But now they have defined to mean any business activity which is permissible under any law in India or overseas, as the case may be, would be treated as a bona fide business activity, which would be there. But the important is that the foreign entity should be engaged in some bona fide activity for undertaking any ODI investment, either directly or through the SPV, which is there. The second element which is there, that if the ODI investment is made in a debt, under the current under the erstwhile regulation, the only requirement need to have an equity participation, and there was no threshold limit to provide it as to how much of the equity have to be done for anyone to make a debt investment, which is there. So the typical practice was that if at all a debt investment were to made, a nominal equity stake was taken, and then debt investment would have been made possible as such. But now they have brought in certain additional conditions for any Indian entity to make a debt investment. The debt only once the ODI is made and the Indian entity has control in that foreign entity, then only the Indian entity will be eligible to make the debt investment. And as we saw the definition of a control among other things, it requires a participation of 10% or more of the voting rights into the foreign entity. So unless and until the Indian entity has more than 10% of voting power going forward, they cannot make any further debt investment. Whatever debt investment made prior to this, even though it would have been below the 10% threshold voting power limit, that would continue, they can continue to hold it as such. But if they want to make any further debt investment, then they have to bring up that equity or bring up that participation of up to 10% of the voting power as such. Second, there has to be compulsorily a loan agreement which has to be backed up, and the AD banker are required to see whether these loan agreement are there before, in a sense, processing the investment of the debt investment into the overseas entity as such. And there is one more element which has been mentioned, that the debt component should be subject to an ALP interest charged as such. So the ability for the Indian entity to provide interest-free debt, keeping aside the transfer pricing regulations for the time being, it will not be possible going forward, as there has to be a compulsory arm's length interest to be charged. It is very important to note that they have used the term interest to be charged from a debt perspective. And as we saw, they have clarified that the redeemable preference capital or the OCRPs as would also be treated as a debt. And inherently, it doesn't have an interest charged on the pref capital. It is the dividend or the redemption premium which is there. So in that context, how do you interpret the term interest qua investment through the preference capital as such? But if we go by the letter of spirit, one have to be interchangeably use interest to mean also any coupon, dividend or premium to have an element of arm's length aspect to be built in as a return on that pref capital investment which is there. The another changes which are brought in under the financial commitment which are there, that the 400% limit of the financial commitment continues to be applicable, and that 400% limit was applicable on the net worth. Earlier, the net worth was defined to mean paid up capital and free reserve, but now they have made changes to have net worth to be in accordance with section 257 of the Companies Act as such, based on the last audited balance sheet. And if it is a LLP or a firm, the capital contribution and any undistributed profit which is there, less any accumulated losses or the fictitious assets which are there. So again, the test of quantifying the financial commitment and the 400% limit will undergo change now, depending upon what the net worth is computed based on this, depending upon these two category of the Indian investment. Under the erstwhile regulation, there was an ability for the Indian entity to club the net worth of holding company and subsidiary company to arrive at the 400% limit which is there. Now that has been completely done away with, but some dispensation is there to say that an holding company or a subco can provide guarantee for to the Indian entity or for the Indian entity's investment into the overseas subsidiaries. And they have also done away with the requirement that earlier the guarantee could not have been provided to the second level step down subsidiary, but that has been completely done away with. So while for the monetary component of the financial commitment, the clubbing of net worth of subsidiary and holding company is discontinued. So far as guarantee is concerned, still the holding company or the subsidiary company can provide the guarantee. But the utilization of that guarantee amount while computing the financial commitment would be considered as being utilized qua the holding company and subco is providing that guarantee, and not qua the investing entity. So if suppose A company is the investing entity and guarantee by any reason is provided by its subsidiary B company, so the value of that guarantee to be treated as part of financial commitment shall be considered to be utilized against the limit of the B company and not that of the A company which is investing. Going further, if the entity is a promoter who is providing the guarantee, either company or the individual as such which is there, then the limit for the financial component, financial commitment would be considered as that of the limit of the Indian entity which has made the investment as such. So this is the significant change. Again, from a pledge of shares, and when we say the pledge of shares means pledge of shares of a foreign entity or creation of any charge of assets of the Indian entity making the investment or of the foreign entity investing entity as such. The thumb rule or the overall rule is that if there is a fund or fund-based facility for which the pledge or the charge is created, which is for providing the facility to the overseas entity, that have to be reckoned as a for the purpose of financial commitment, and hence the limit of 400% have to be seen there. But if it is there, the facility is to be used for the Indian entity or any Indian entity subsidiary or the below the Indian parent as such, that is not to be reckoned as a financial commitment limit as such. Again, when an ECB is taken, an ECB taken is permissible to make investment into the ODI investment as such, then the entire amount of the ECB for which the investment has been made have to be considered as a part of a financial commitment. But if there is a pledge of a share, so ECB is borrowed and investment is made into the foreign entity, and that foreign entity's shares have been pledged to get a funding facility for an overseas entity for which already that amount is taken as a part of a financial commitment, then the ECB component need not be separately considered as a part of a financial commitment. And only the value of ECB in excess of the value of the pledge of shares, that would be treated as a part of a financial commitment. So there is not, in a sense, a double counting as such. It's only the delta that have to be considered while computing the limit of the financial commitment. Now, now coming to the next step, so we discussed about what are the governing regulations for an ODI route from an Indian entity perspective. Now, the governing route for the OPI investment by an Indian entity. So earlier, as Puneet also mentioned, the listed entity were permitted to make the OPI investment as such, which continues, and there is an added element to say that there can be a reinvestment of an OPI, meaning if already an OPI investment is made and which there is a disinvestment or a transfer, under the earlier regulations, you need to bring back the sales proceeds within the timelines prescribed as such. But now, one has the ability to reinvest, provided that reinvestment is made within the time limit permitted to bring back the funds. So long as I made the reinvestment within those time limits, I need not have the requirement to bring back those funds as such. From an unlisted Indian entity perspective, earlier it was not permitted to make only OPI. Having said that, today the OPI, unlisted Indian entity can make OPI only in respect of permissible modes, which are only 4 permissible modes, being right issue or bonus issue, capitalization of any specified dues, swap of security, merger, demerger, or anything which is done as a part of a restructuring which is there. So anything as a part of a fresh investment or a pref allotment or a transfer in that sense is not considered. So there are very restrictive modes within which the unlisted Indian entity can undertake an OPI investment. There is an all-encompassing investment limit of 50% of the net worth, which is applicable for both the listed Indian entity and the unlisted Indian entity based on the last audited balance sheet. And it is also mentioned that the last audited balance sheet should not be exceeding 18 months from the date of the transaction as such. So one need to factor the timing of the audited balance sheet, and in that sense, the time limit which is applicable for computing the 50% net worth limit. Now we move on. What are the key governing guidelines pertaining to the ODI and OPI by a resident individual? So both are now governed by this regulation. In terms of the ceiling limit, it continues as to the same ceiling limit which is applicable under the current regulations for ODI by a resident individual, being LRS limit, which is currently at USD 250K as such. As we discussed earlier, since the OPI investment were not governed by the ODI regulations, virtually all the investments by resident individual into an overseas entity which did not satisfy the ODI criteria were undertaken under the LRS scheme route as such, where it was just a 250K, and the attendant conditions which were there for the ODI were in a sense not applicable there. But with this change in the legislation, they have also amended the LRS scheme, which states that any overseas investment by a resident individual would be governed by the new legislation, and there will not be an independent avenue or the independent route available for making investment outside India. So therefore, any investment by a resident individual have to be within the ODI or the OPI bracket, which is provided under the new legislation as such. From an ODI investment perspective, it has been mentioned that the ODI investment can be made or hold only an operating entity which is not engaged in the financial services activity. And the second condition is that if the resident individual is having control, meaning example 10% more voting right in the foreign entity, then such foreign entity shall not have a step down subsidiary. Under the erstwhile regulations, I could not have invested into FS sector entity, or that entity also could not have any step down subsidiary. That was completely bar which is there. But they have given a relaxation here that if you do not have a control, then the overseas operating entity can still have a step down subsidiary without any restrictions as such. It has further been clarified that if the operating entity, after making the investments, makes any step down subsidiary investment, it has to be ensured that the resident individual do not gain any control in the foreign entity as such. So a resident individual cannot have control across the investment timelines so far in order to ensure that the foreign entity is not making any step down subsidiary. If you want to make a step down subsidiary investment, ensure that the resident individual is not having control in the foreign entity. From an OPI perspective, which is not an ODI as such, again, the ability of reinvestment is there. So there's no requirement to remit the fund back. And as Puneet already mentioned, that investment into the units of an investment fund overseas would be treated as an OPI as such. The earlier transaction we declared where there was like a monetary amount of investment that were to be made from an ODI and OPI perspective. But there are certain other modes which are permitted to make investment, which is not a monetary, but which are completely permitted from an OPI perspective or an ODI perspective, and for which the governing guidelines of being into financial service sector, or for that matter, having a step down subsidiary with control, is in a sense not applicable. One of the important element which were there from a gift perspective is that the earlier regulations were silent, or in a sense permitted gift of any foreign security to a person resident in India from a person resident outside India as such. And while there was no clarity in terms of whether the ODI regulations were applicable or not applicable, but the general prevailing view was there. For those gift transactions, the ODI regulations doesn't apply, and hence the attendant conditions or the reporting also were not required. But from a gift perspective, they have now clarified that gift of shares of a foreign entity from a person resident in India is only permitted if it is a relative, and if gift have to be received from a person outside India, it have to be in accordance with the FCRA regulations, foreign contribution regulation as such. So one have to therefore see the FCRA regulations to see whether it is permissible to get gift from outside India, and if it is permissible there, then only one could get the gift. One of the aspect even in the FCRA is that any gift received from a foreign relative were not treated, or were not or in a sense were permissible from an FCRA perspective, though with some reporting which was there. So that should continue, considering that this is permissible under the FCRA. The gift by a foreign relative to the Indian person resident individual as such. In same breath, any gift from a resident to non-resident is also not permissible. And at the same time, when any gift which is to the permissible limit which are there, that will not be reckoned towards the LRS limit. Meaning thereby a conclusion could be drawn that therefore the attendant conditions or the reporting requirements should not be applicable to this. But if a clarity is provided on this aspect, whether any reporting is required or not, that would be welcome.
I think Abhishek, maybe we should, we're coming to the end of our timing limit. We should keep some time open for responding to the questions which are there. So unless there's something else which you want to quickly cover, let's move on to the questions.
Just 5 minutes, I will just quickly cover on the round tripping issue, which would be.
Yes.
So currently, any round tripping, which is commonly known as for the ODI FDI structure, that require RBI approval, prior RBI approval. In the new regulations, they have provided that you can have the ODI FDI, or that's what the interpretation come in, so long that it is not resulting into the 2-layer of subsidiaries. And what is, they also defined the subsidiaries to mean an entity in which the foreign entity has a control. Therefore, one have to compute the layering of this subsidiary basis this definition below the foreign entity, which is an example, which is below the F code, there should not be more than 2 layers of subsidiary as such for the purpose of making investment. So therefore, an Indian parent making investment in foreign company, which underline has the one SPV, which could be either in the foreign or the Indian jurisdiction, that can have an opco below that. but there cannot be below anything up to in terms of satisfying the criteria of the two-layer subsidiary which is there. Then so in a sense, conversely, if it is below 2 layers, there is no requirement to obtain any prior approval. That's what it suggests as such, because they have provided a restrictive conditions only if there is more than 2 layers of subsidiary. At the same time, if on an acquisition already an acquired structure has more than 2 layers of structure as such, then there is an ability to go through the RBI by virtue of Rule 9, which is there, that one can approach the RBI for any prior approval to grant the approval for making investment as per the conditions which they deem fit, which is there. Here, one important element which is there, that if suppose the ODI FDI is done only through a single SPV, which is purely an SPV and not having any business activity, whether that can be considered to be part of an automatic route, because it is compliant with the 2-layer subsidiary criteria. But the important element is that, as we mentioned earlier, the ODI is permissible only if it is engaged into a bona fide business activity, the foreign entity, through an SP or whatever. So therefore, it would be essential to know that if an SPV not having any activity, whether can be treated as being engaged into bona fide business activity or not. And that's where I think it would be very important to have that the foreign SPV, apart from merely holding, should have certain bona fide activity as such, or making investment itself can be considered as a bona fide business activity. But clarity on that would be in that sense very welcome. So I think there are other aspects also, but considering the timeless, we can address the questions. So I'm just picking up the questions as we are receiving. So one is, if we are making an investment in a holdco of a company, say a Singapore based, and that holdco invests in Indian subsidiary, do we have any regulatory concerns as a bank? We just discussed this aspect that the ODI FDI structure, so long as it is not having more than 2 layers of subsidiary, that should not, technical reading should not have any problem. But the only element which is there, that if the foreign entity is an SPV and not having any other activity, whether it will pass the muster of a bona fide business activity, which is there. So if it passes the muster, in that sense, based on the pure technical reading, it should be. But given that,
I think the way one would probably address this is to say that with the new regulations, round tripping has been given a go by. Round tripping is specifically permitted. In fact, if you look at the draft regulations of August 21, they had a restriction that round tripping would be permitted if there was no attempt to avoid taxes. Even that has been done away with. So round tripping has been specifically blessed. However, the point which Abhishek is making is that you cannot say that you make an investment in an SPV whose only business is to make an investment in India. Because remember that we still have rupee not being fully convertible on capital account. So if we had just an SPV overseas which had no business activity, and the only activity that it undertook was to make an investment in India, then probably it may fail the test of making investment overseas in a bona fide business activity. And therefore, one should view this entire aspect of whether there is round tripping permitted or not from the lens of this overall approach, rather than to say that round tripping is permitted or not. The one other set of questions which has come up, and Abhishek, you might like to address is the interplay between ODI and LRS. What is the interplay at this point of time on between these two regulations?
Yeah. So as we start today, any overseas investment, either it could be an ODI or an OPI, would be governed by the new ODI regulations only, and one will not have an ability to resort to the LRS scheme which is there. And to this effect, even the LRS scheme has been amended to clarify that any overseas investment now would be permitted under the LRS if it is in accordance with the new ODI regulations which have been enacted.
Puneet, there is a question by Soumya, which is considering unlisted debt instrument has been carved out from the definition of OPI, and as such investments will not fall under the ODI category as well. How will the subscription by an Indian entity into redeemable preference shares or optional shares, etc., in foreign entities be governed?
Right. So that's the confusion part which we actually touched upon in our presentation as well. That if it is an unlisted entity, clearly it would qualify as ODI, but it has to be an equity instrument, and one would need to look at the definition of the equity instrument. If it falls under the definition of equity instrument, either in the directions, then it would be permitted under ODI. But if it is not, and it is also not covered as OPI, then in that case, the actual investment will not be permitted at all. But to my mind, it should fall under ODI, under the definition of equity, and therefore the investment should be permitted under ODI and not OPI.
Thank you, Puneet. And Puneet, one other question which I think you did answer. The SEBI rules which specifies AIF to invest overseas with India connection, will that Indian connection is still required?
Yeah, so that's not required. It's a very significant amendment, so that India connection condition has been done away with, and therefore AIFs are free to invest in any overseas entity without India connection as well. Of course, there are overall limits which are laid down by SEBI in terms of the total investment which can be made by all AIFs put together. Those conditions continue to apply.
Another question again, Puneet, on financial services sector is that if there is an unregulated Indian advisory entity which provides investment advice to offshore clients and is exempt under SEBI RIA regulations, would it be regarded as entity not engaged in financial services sector?
Yeah, interesting question. Either it could be regarded as a non-financial services entity, or it could be regarded as a financial services but unregulated. I think it may fall under the latter category. It's a financial services entity which is not regulated and may not qualify to make overseas investment because there is no regulator which is regulating this entity, and therefore there is no approval which may be forthcoming. But it's a gray area. It's a gray area.
Abhishek, a question is that if there is a manufacturing company in India and that invests in property outside India, will it be treated under ODI as before? What are the issues around that?
So the point is that the current ODI investment only talks about the investment into the foreign securities, and within the same legislation, they have provided enabling provision to make direct investment into an immobile property outside India, which would be outside the ODI regulations. And therefore, the manufacturing company in India will have the ability to make investment property outside India, which can be used for the purpose of stay of the office, for the purpose of stay of the director's employees, or for the purpose of the office, which would be outside the ODI regime for securities as such.
Another question is, can an individual make investment in a partnership, say an LLC in USA? LLC does not require any issue of a share certificate, and it is by way of a capital contribution. If yes, does individual need to form an ODI? How can such an investment be made, Abhishek?
So they have defined the term foreign entity to mean any entity which is having a limited capital and which is either incorporated or registered or something which is there. And in the directions, they have separately clarified that a limited liability company should be treated as a foreign entity as such. So therefore, any investment into that entity would be eligible for an ODI investment in an unlisted security, and consequently, the compliances or the reporting from an ODI perspective have to be done under new Form C.
And just to add, sorry, Dinesh, just to add,
Yes,
I think it's a very, very interesting question because LLCs sometimes is a very peculiar entity, not recognized either as a limited company or a partnership firm. The question talks about this as a partnership firm, but if it has the features of partnership firm with unlimited liability, clearly there could be an issue. But if it is a limited liability, definitely the spirit is very clear that it's ODI is permitted in such an entity.
Another question, Puneet, is on AIF. can an AIF formed in India invest in units of a fund in an international country? We had spent some time discussing this yesterday.
Right. So I think the issues would arise. AIF, first of all AIF investments would be considered to be OPI. That's the clarification which is given in the directions. And any investment into investment fund should be permitted under the OPI regulations. I think that should be possible.
There is a question, and I think the answer could be fairly simple. Is there any new regulation with regard to write-off of the ODIs? Is there any change there? I don't think there's particularly any.
There are significant changes. Yeah, Abhishek.
Yeah. So there are two aspects. One is write-off arising on account of transfer of shares, which under the existing regulations were permitted with a certain restrictive conditions. Now that condition is completely done away with, so long the transfer of shares is backed by an appropriate pricing valuation which is there. So if there is a pricing guidelines are met and the transfer of investment is entailed in write-off, that is now completely permissible without any RBI restrictions or approval as such. There is a second aspect of a write-off which is part of a restructuring as a book write-off into the books of account, considering that there are a loss making which are there. So that have also been liberalized to say that if the foreign entity is incurring losses for 2 years, then there is ability to write off the debt proportionate to the accumulated losses which are there. And if the losses or the investment value is beyond a particular threshold, that write-off or the justification of that write-off needs to be backed by a valuation report. So yes, there are permissibility from an write-off for transfer as well as write-off in the books of account, provided the threshold limits are met.
And maybe a last question, and other questions, of course, we'll try and respond individually. What are the examples of OPI which is not covered by ODI?
So it would be typically an investment into an listed entities, which is below 10% threshold or not having any control criteria, and any investment into an overseas fund entity which are regulated outside India, that they have clarified it to be part of an OPI in a very, very broader sense.
So we still have a host of questions which have not been answered, and then we have paucity of time, and I'm sure we'll reach out individually to the people who have raised questions and try and respond to the questions. And also, as I mentioned when we started out, no businessman, no set of professionals sitting in a cabin can think of all the business situations, and therefore as new and new business situations evolve, one will sort of keep on analyzing these provisions as we have done in the earlier provisions. Having said that, as we discussed and as Abhishek and Puneet brought out, there are several very, very significant changes. The fact that we have been able to touch the holy cow of round tripping itself shows the government's desire to ensure that regulations are eased off. That said, there could be certain situations where things which were earlier permitted are no longer permitted, etc. In fact, one of the follow-on questions which came to a point which Abhishek and Puneet both responded about investing in an LLC is that an authorized dealer is insisting on a share certificate, etc. Those are practical issues, and I think there's a limit to which one can answer those practical issues. But that said, I said the attempt is to liberalize the attempt, particularly the two things, takeaways, which I would look at. One is the point on financial services sector, the ability on the part of people who are not engaged in financial services sector to make investment in financial services sector, and the round tripping are two very, very major takeaways. Other changes are again important, but I thought these two are very, very standing out. Thank you so much, Abhishek. Thank you so much, Puneet, for the analysis. And thank you all for joining in. I hope you had some good takeaways. Feel free to write to us. We'll respond to the questions already raised. And if there are any more questions, we'll be happy to respond. Thank you all again for joining. Thank you, Abhishek. Thank you, Puneet.
Thank you.
Thank you.